a trainee solicitor in the employment team here at Buxton Coates Solicitors. In this video, I'll be explaining what a flexible working request is, how they are made, how the process works, and what an employer can and cannot do. A flexible working request is where an employee requests to change their usual working arrangements. It's about when, where, and how they work. In England and Wales, employees have the right to make a flexible working request from day one of their employment. They no longer need to have 26 weeks of service. You do not have to be a parent or carer either. An employee can also make up to 2 requests in a 12-month period. A flexible working request should be made in writing, stating the changes that the employee wants to make and when they want those changes to take effect. It's important to note that employees no longer have to explain the impact they think this change may have on the business. Once an employee has made their flexible working request, it is important that employers must deal with the request in a reasonable manner. They must consult with the employee before refusing their request, and an outcome must be reached within 2 months of the date of the original request, unless an extension can be agreed with the employee. There are 8 reasons why an employer can refuse a flexible working request. Extra costs that will damage the business. The work cannot be reorganised amongst other staff. People cannot be recruited to do the work. Flexible working will affect the quality of work. Flexible working will affect their performance. The business will not be able to meet customer demand. There's a lack of work to do during the proposed working times, or the business is planning changes to the workforce. A refusal must be genuine and evidence-based. When an employee has made a flexible working request, the employer has 3 options. They can accept the request, deny the request, or deny the original request and suggest alternative arrangements. It is important to note that if alternative arrangements are offered, the refusal of the original request must still comply with one of the 8 reasons previously mentioned. It is also possible to have a trial period for the requested arrangements. This allows the employer to see how the request will work in practice. If an employer ignores the process or refuses the request without proper consultation, an employee may be able to bring a claim in the employment tribunal. Poor handling can also lead to a discrimination risk, for example, if the request was in relation to a disability or childcare arrangements. Flexible working requests are now the norm, not the exception. It's important that if you're an employer, you get the process right. Contact us today for expert employment law advice.